Let me ask a few quick questions. How many of you, if you don't mind sharing, now I have to behave, my wife's here. How many of you, if you don't mind sharing, have a will currently? Raise your hand. How many of you, keep your hands up, how many of you did that will within the last 5 years? Okay, good. How many of you are married and have at least one child but do not have a will? Okay, y'all listen up later. All right, so I have about 4 hours worth of materials. Then we'll squeeze into about 50 minutes. All right, so I'm going to get back here because they told me not to wander too much, and I have a tendency to wander. I want to talk about estate planning first. I may hit on some estate administration at the end. I'm an attorney. I practice in Spartanburg. I've been practicing 24 years in November. About half of my practice nowadays is estate planning or estate administration work. Strangely enough, the other half is civil litigation. So I get to go to the courtroom and argue about stuff, or I get to help people figure out what they're going to do when they pass. But I want to hit on some primary documents that I talk to everybody about when I meet with them. 4 things in particular. So hang on tight. My mom's from New Jersey. I tend to talk fast, so y'all have to listen fast. All right, so the main things I want to talk to you about is the same lady. It's not just at death. A lot of this has to do with what you're planning and what you're doing prior to your passing, or what's going to happen while you're still alive. And 3 other documents up here we're going to talk about. We're going to talk about a healthcare power of attorney, a durable power of attorney, a living trust, and we're going to talk about a will. Those are kind of the 4 big documents. Now, what this is not intended to be, I have to say this, I'm an attorney. This isn't legal advice. I'm not giving any of the specific legal advice because everybody's situation is a little bit different. And what this is not supposed to be is all-encompassing. I'm going to talk about 4 main documents that almost everybody should think about. There are a lot of other devices out there that we talk to people about in certain specific situations. I'm also not a tax attorney. So when you have a tax-related question, my answer, if you're my client or you're not my client, is talk to a tax preparer. Those people know tax laws a lot better than I do. So, but I want to go through these 4 documents primarily, talk about what each one of them does, let you get a feel for those. And then if we have some time at the end, I'll be happy to answer some questions. And then again, you'll get my contact information if you need it. I'll come back to that at the end as well. And you're certainly free to reach out to me through the church directory or stop me. That's part of the reason why I didn't wear a suit. If I wore a suit tonight just because this was being videoed, you wouldn't recognize me next Sunday because I rarely wear a suit. All right, so again, durable power of attorney, healthcare power of attorney, last will and testament, and what's inter vivos or a living trust. Inter vivos just means among the living. So some people call it inter vivos trust, some call it a living trust. We'll get to that a little bit more. So I'm going to go in this order. South Carolina Durable Power of Attorney Act. Simplest way to think about this, there's a couple of different parties. The principal is the person who signs that document. So if I'm creating a power of attorney, I am the principal. I name my wife as my agent. So there's the other terms that we're talking about. Principal and agent. You might be shocked to know attorney's words mean something. So principal is who's signing the document. Agent's the person I'm giving the authority. These are straight out of South Carolina statute, but just think about it this way. A power of attorney is a document where you designate an agent, and I usually do at least one alternate, to be able to act on your behalf and do anything and everything that you can do. And again, leave it to a lawyer. My durable power of attorney document is between 13 to 15 pages. You wouldn't think it would take that many pages to say anything and everything that I can do, but I list about anything and everything that you can do. So document designates an agent. The principal signs the document. The agent is the person who has that authority to act. The term durable, some people say, what does that mean? In South Carolina, every power of attorney is deemed to be durable unless you say it's not. And all that means is when I lose the capacity as the principal to do the things that I used to be able to do, my agent still can do them for me. I'm going to stop real quick. This isn't on my slide. The reason why this document is important, I tell people if you're 40, you need one of these. And here's why. If you became incapacitated, freak car accident, head injury, you have some kind of trauma that causes you to be unable to care for and maintain your finances, where you live, how you manage your day-to-day affairs. It can happen quicker than we think. If you don't have an agent that you've designated, somebody in your family is going to have to go to the probate court, have you declared incapacitated, have a guardian or a conservator appointed. Let me tell you something. That document, to have it prepared by most attorneys, costs you 1/10 of what it costs to have somebody appointed guardian and conservator. Right now, I quote people between $2,500 to $3,500 to have a guardian and a conservator appointed. And that's not just for attorney's fees. That's because there's another attorney that has to be involved, a guardian ad litem has to be involved, $300 filing fees from the probate court. That document is a no-brainer if you have inherent trust in the person you're going to designate as an agent. And I'll say that because people say, well, here's the fancy legal term. Y'all can remember this one. A fiduciary duty. Once the agent is appointed, they have a legal duty to do what's in the principal's best interest. It's called a fiduciary duty. So I appoint my wife as my agent. I become incapacitated. She steals all the money in the bank account, goes down to Florida. Well, my sons might be able to sue her for breaching the fiduciary duty, but if she stole all her money and went to Florida, she's probably spent it by the time they catch her. So it's kind of a hollow threat, but it is a legal remedy there. All right, so the durable power of attorney has to be signed by the principal, and this is what kind of catches people, or signed in the principal's presence at the direction of the principal. So if I can't write, I've had a stroke, but I'm competent. I'm legally competent to sign. I can tell my wife to sign my name for me. That's perfectly permissible as long as it's done in my presence. Also, I have to have 2 witnesses to that document and the acknowledgement before a notary pursuant to that South Carolina Code section, which nobody knows what that is. So there it is. Basically, what it says is the notary saw that person sign the document. And a lot of times I also say that the witness also swears before the notary that they saw the person sign the document to him. So what is the legal capacity for a power of attorney? The same capacity to enter into a contract in South Carolina. So if somebody can sign a contract in South Carolina, which means they're an adult over the age of 18, and they are competent enough to sign a contract, they can sign a power of attorney. I actually have a case right now where we're litigating over that very issue as to whether or not the person had the capacity to sign the power of attorney because the people who were the former agent don't like that he's got a new agent. All right, so that was durable power of attorney in a nutshell, very quick, but again, very important document. Allows you to designate someone who can manage your affairs. Why do most people do a durable power of attorney? While they're able to do their things, they want to be able to do it, but when they can't, they want somebody lined up and ready to go. So that's why it's important to have it in place sooner rather than later. It's a very sad experience when you have to look at a family member and say, I'd love to be able to help your mom, but I don't think she's competent enough to do a power of attorney. I'm sorry. I can help you with the guardian conservator action. It's going to cost you a whole lot more money. And that's tough, but that's the case that runs in from time to time, and we have to deal with that. This is almost a giveaway. The healthcare power of attorney is another type of durable power of attorney, but it has a limited scope. The durable power of attorney is very broad. It is effective from the moment you sign it. The healthcare power of attorney is limited to medical or healthcare related decisions. Same concept though, you've got a principal who signs it, you've got an agent or a second agent or a third agent, depending on how you create or set up the document. That is the person who can then act on your behalf. What's important about the healthcare power of attorney is what we call a springing power. It springs into effect when you are incapacitated. So as long as I can have a healthcare power of attorney in place where I say my wife is my agent, as long as I can tell the doctors or the medical providers yes or no, they're going to listen to me. When I am incapacitated, they're going to look at my healthcare power of attorney and say, okay, wife is first on this. We're going to talk to her now. If I regain my capacity later on, they're going to start communicating with me again. So that's why it's called a springing power. It springs into effect during my incapacity. Similar concept here. It's executed before 2 witnesses, has the same type of notary provision. In South Carolina, there's what's commonly referred to as a statutory form. Now, you don't have to use a statutory form in South Carolina. But what I'll tell you is, as an attorney, that's what I have been using pretty much from day one. Because when the General Assembly says, we think a healthcare power of attorney should look substantially like this, and they give you the form in the statute, you don't want to tweak it too much, at least I don't want to, because one of the reasons I want to do that is I want to make sure it's consistent with what they may be used to seeing. Also, I want to make sure it's consistent with what medical providers are used to seeing. If you see a statutory form being presented at the doctor's office regularly, they know where to look for certain things. What's different about this one, again, springs into effect during incapacity, limited to healthcare-related decisions, and it also allows you to give some advanced directives. And we'll go through those in just a second. And what those are organ donation. And again, no shocker here. Paragraph 5, guess what? That's paragraph 5 in the statutory form. It basically allows you to tell everybody in advance that your agent may or may not consent to organ donation. This is straight out of the healthcare power of attorney document that I use. And when you're going to sign that document, you just initial which one of these is your preference. I will stop here for just a second on paragraph 6 because some people have heard of a living will, declaration of desire and natural death. What that is a document that I used to draft and I used to use a lot more frequently before the statutory form came into place. Basically, what that document is for, some attorneys still use it. I work with an attorney who's been doing estate planning work for about 30 years now exclusively. He has a separate document called a declaration of desire and natural death. Basically, what that is what a lot of people think of as do not resuscitate, or I don't want to be on life support. I don't want to have artificial means of hydration and nutrition. You're going to see in a second why I don't do that anymore. Is because paragraph 7 talks about what are my statements with regard to life-sustaining treatment. So basically what paragraph 6 there said is if I have a declaration of desire and natural death, I want it to be honored. I don't want you to have an inconsistent declaration of desire and natural death and then turn around and have these paragraphs be different down the road because then it's confusing to me. So I stopped doing a separate declaration of desire and natural death, and I just used this document to take care of that same type of an issue. So basically what we have here is this is with regard to life support or life-sustaining treatment. There's 3 options that the way this is set up that you can do. Leave it up to your agent. In other words, let your agent decide at the time what they think is appropriate with regard to life-sustaining treatment. Again, you've got language in the way this is drafted that says, I don't want my life unnecessarily prolonged. I want to take into consideration financial situations, what my beliefs are, my suffering, my condition of time. So that's one option. Leave it up to your agent to decide. The second one is withhold life-sustaining treatment or life support if certain conditions are met. And I can almost put this, if it's incurable or irreversible and without the administration of life-sustaining treatment will result in death in a relatively short period of time, or if you have a state of permanent unconsciousness, sometimes referred to as a vegetative state. Again, medical professionals make those determinations. If you initial that box, family presents that, and then they know that they can take you off life support because that's what you told everybody in advance when you were confident, had the ability to understand and enter into a contract that that's what your directives are. The third one, I paraphrase, give me all you got. So you basically leave it up to your agent, withhold or withdraw if those medical conditions apply, or give me all you got, which means keep me on life support as long as possible. I don't really care how much it costs or whether it's a good idea or not, just do it. All right, so again, those are the things. People initial one of them, you won't be surprised. It's A or B in most cases. This is the statement with regard to artificial means of hydration and nutrition. Again, this is one of the advanced directives within the healthcare power of attorney statutory form. Same situation, same options. You leave it up to your agent. The difference here, and I just want to make sure I clarify this because to be perfectly honest, at first, I had to read through this section a few times to make sure I understood the timing. The timing here is this directive only applies when you have been taken off life-sustaining treatment. So if you have been taken off life support, your body is shutting down. The question is, do I get artificial means of hydration or nutrition, sometimes called tube feedings, during that stage? 3 options. Leave it up to your agent to decide, withhold or withdraw, or give me all you got. Again, same situation. You initial what your directive and your preference is so that the agent knows your wishes. I want to back up for just a second. I'm not going to back up on the slide because, well, I can't buy for it. There you go. In most of these situations where it's leave it up to the agent, what I commonly tell people is if you're going to leave that discretion to your agent, you need to really have a heart-to-heart discussion about what your real wishes and intent is. And why did you leave it in their hands to decide? And again, I've not had to go through this scenario. My dad made it very clear what his wishes and desires were before he passed. But I tell people, if you're leaving up to your agent, because you could have co-agents, you could have a situation where you've got multiple children as your co-agents if your spouse isn't able to serve. That's a lot of pressure. And that's why I tell people, if you already know you don't want to be on life support, why even bother them with that discretion or that decision? So again, that's a personal choice for everybody. I don't initial these boxes. You do when you sign the document. But if you're going to initial that one, I do commonly counsel people to say, look, you've initialed that. That's perfectly fine. But sit down and talk to those family members and tell them what your real wishes and desires are if you're going to have them make that decision at the early time. All right, so let's get to the one while most people are here. A will. A will speaks of death. Those first 2 documents speak while you're alive. They expire when you do. So the authority, I have people call me all the time, well, I'm the agent on the power of attorney, but mom died 2 weeks ago. Guess what? You're not an agent. Your power to act under a power of attorney expired when she. So let's talk about a will, and in a minute, or not a minute, probably 22 minutes, I'm going to talk about some of the things why you may or may not need a will, because we're going to talk about probate avoidance. But a will is simply a document that speaks at your death, tells the court, your family members, and the world how you want your things to pass. There's some scary law in South Carolina, so we'll talk about some of the funny things. It has to be in writing. We don't have oral wills in South Carolina. You have to have a will, has to be in writing. Can it be in your handwriting? It can be. It's called a holographic will. But here's the thing. It's still, even if it's in your handwriting, it has to be signed by someone who is of sound mind and not a minor. Under that statute, because this is the code section 62-1-201, paragraph 47, leaving up to the attorneys to have, or General Assembly to have that many definitions in one code section. There's more past 47, but number 47 is whether or not a minor is defined in that code section. That means somebody under the age of 18, except if they are married and emancipated from a family court order. So if somebody can get married under the age of 18, they can get emancipated by a family court order, and then they can sign a valid will, even though they're under the age of 18. Thankfully, I've never had to deal with that issue, but my will does provide for that and say that the testator is over the age of 18 or they're emancipated. But you can be in a sound mind. We're going to talk about that a little bit more. That's the fun part. And it has to be signed by that person. Has to be in writing. Down here, this code section has to be in writing. Signed by the testator, or similar to what we talked about earlier, can be signed at the testator's direction by some other individual. It has to be signed by two witnesses. Now, at the very bottom, it says disinterested witness is the safest approach. What that means is, if I have a will and it gives something to my wife and my two sons, I do not want my wife or my two sons serving as a witness. If somebody is named in the will is also a witness, unless they get less under your will than they would under the intestacy statute, you don't have two witnesses anymore. They have to be disinterested witnesses. In other words, don't have somebody sign as a witness to your will if they're named in your will. That's the safest approach. Again, there are some exceptions to that, but generally speaking, don't want somebody who's named in the will signing, because you may not have a valid will because you may only have one witness, not two witnesses. All right, so that's the key. This document speaks at death. Now, the reason I started earlier and said how many of you are married, had at least one child, but don't have a will. You don't have to have a will in South Carolina. If you don't have a will in South Carolina, there's a statutory scheme. It's called intestacy laws. In South Carolina, you have a will. It's called a testacy. It's testate versus intestate. Intestate deals with your heirs if there's no will. In South Carolina, let me tell you how that works. If you are married, everything goes to your wife. If you are married and have a child, half goes to your wife or your spouse, half goes to your children. So, when did I do my first will? The week after Ethan, my oldest son, was born. Because at that point, I didn't have a whole lot, and I didn't care if it all went to my wife, because I knew that's where it was going anyway if I had a will. But once my son was born, I didn't want half of my estate going to an infant. I don't want half of my estate going to a 22-year-old. Right? That was the first time I did a will, was when my son was born. But again, if you're married, you don't necessarily have to do a will because it might be going where you want it to. But I want to talk to you about some of the reasons why you might want to do one, even if that is the case. Here's some of the benefits to a will. It allows you to tell everybody in advance what you want to have happen, whether it's consistent with the intestacy statute or not. It also, and maybe more importantly, allows you to designate who you want to be the personal representative. That may be a new term to some of you. We don't call it an executor in South Carolina. You have the executor, executrix, says male or female. South Carolina, we just call it a personal representative, or I call it PR for short. So your PR is the person who administers your estate and handles the affairs for you, consistent with your will. So the idea of having a will allows you to designate who that personal representative is, and maybe who at least the alternate would be if that person can't serve or can't continue to serve for any reason. Also, it allows you to give the personal representative some additional powers or authority that they otherwise might not have. One of the fundamental powers that I look at during the state administration is I want the personal representative to be able to sell property. If you don't have a will, they have to get permission from the court to sell any real estate or any personal property above $15,000. So that kind of ties the hands of the personal representative. And again, y'all might have heard this earlier, if you happen to file an action with the probate court to ask permission to do something, you have to pay a filing fee. It's $150 to file that petition. And I have to do that in almost petitions to sell real property. I do those frequently in almost every situation. There's an intestacy estate. They want to sell a piece of property that mom and dad lived in, and nobody's going to come back to South Carolina. They're all out of state. Now they got to go through this process of getting permission to sell real property. Maybe they got a neighbor who wants to buy it, who's sitting there anxious, ready to go, but we got to wait until we get the hearing. We got to get the court order and all that. So it's a drawn out process. Let me tell you the other thing too. Real world scenario, to do a simpler will, I don't call anything a simple will. Nothing simple about a will. It controls where things go at death. But there are simpler wills and there are more complex wills. A simpler will costs about what it would cost to get a bond, because if you don't have a will and all the family members don't agree, your personal representative's got to go to the insurance company and pay to get a fiduciary bond. The idea being in Spartanburg County, it's at least $10,000. Not the fee, but the bond. So you got to pay a percentage of that for the bond premium. And the idea there is that protects the family members or the heirs of the estate if the personal representative does bad things and runs off with all the assets. Guess what? If it turns out there's more than $10,000 in the estate, the bond has to be increased, so the premium goes up. So again, to get a bond in most estates, and then if you had to ask permission to sell the real property, you're going to spend more money than if you just get a will. This is not, I don't want anybody's business. Don't come to me. You don't have to use me at all, but don't use online will forms. Usually people get them wrong. They're complicated enough as it is, but I see a lot of people, in most of the instances where I've seen people try to avoid going to an attorney to get a will done, we end up in probate fighting with family members, and it costs 10 to 20 times what it would have cost to get a will. So it might have saved the person who's deceased some money, but it certainly didn't save their estate. So again, anybody who's competent, some great case law, a second on that. Execution in writing, signed by the testator, and then that's the person who forms the will, testator. And then it has to be witnessed to disinterested witnesses. This is a section here, and I'm going to point out 512. There is a section that I put in almost every will. I call it the personal property memo provision. This is another reason why it's good to have a will. In that document, we can say, I might leave a list of tangible personal property items, and I want my personal representative to follow that list. I use Monica's grandmother as an example when I talk to clients about this a lot. When we went to her house before she passed away, she had yellow Post-it notes on a lot of furniture with people's names on it. This is the legal way to do that. You can basically make a list. The other example I use, I grew up bird hunting. My grandfather, I used to use his double-barrel 16-gauge shotgun. My brother used a Remington 12-gauge pump. My dad used a 20-gauge friction. My grandfather had this provision. He could make a list and say, I want the 16-gauge double-barrel to go to Shane. I want the 12-gauge Remington pump to go to Sean. And I want the 20-gauge friction to go to Hank. Just like it's in his will. If my grandfather said, Shane, come sweep out my gutters. I said, I'm too important. I'm a lawyer. I'm not going to sweep out your gutters. He could strike through that and say, I want a 16-gauge double-barrel shotgun to go to Sean. So, I mean, it's a great way. You don't have to do that in front of an attorney. So when it says 512, that's the section that allows for the personal property memo. But you have to have a will that says, I might leave this list. That piece of paper has to be signed by the testator or in their handwriting. Does not have to be witnessed. Has to identify the item and the person with reasonable certainty so we know what you're talking about. The green rocking chair in the living room goes to bed. As long as we know that, we can figure it out. All right. Here's one question I get a lot of people move into South Carolina from other states. Your will from another jurisdiction could be accepted by our court. The question is, was it valid in the state where you did? If it was valid in New York, where you came from, and you still like how it passes things, our court will honor it as long as it was valid in the state when it was executed. Y'all don't have to read this a whole lot. This is just how you revoke a will. The most common way to revoke a will is to a new one. Because even if I don't say, which mine does in the opening sentence, says, I'm so-and-so, I'm a resident of this county, state of South Carolina. I hereby revoke any prior wills, and this is now my new will. If you do a new will, it automatically revokes the prior will unless you specifically say this is to be a supplement. Another way you can revoke a will is you can burn it, you can tear it up, you can cancel it, you can write on it, you can destroy it, as long as you have the intent to revoke it. So, that's basically what I said, is get some presumptions if you do a new will. But again, doing a new will is the most common way to revoke an old will or an existing What I tell people is once you do a new one, probably need to get rid of the old one just because you want the people to find the new one and use the correct one. Or some people are like, I don't want to get rid of the old one. I'm like, well, fine. Let's write on the top of it, send new will dated this. Because you just paid me to draft one, then why would you not want somebody to? All right, here's some of the fun stuff. In South Carolina, you don't have to have the capacity to enter into a contract to have a valid will. All you have to know is the objects of your estate. So basically, you have the ability to understand what you generally owe. The objects of your affection and to whom that person wants to give the property. That's all you have to know. So basically, do I have a general idea of what I owe? Do I know who my family members are who I would normally give stuff to? And who do I want to give it to? I do not have to have a good reason for why I gave it to somebody other than those objects of my affection. This is why I said earlier, I can leave my kids out of my will complete. Quick caveat. The one person you can't leave out of your will without them having some recourse in South Carolina is your spouse. If you die with a surviving spouse and they are not named in your will, absent some kind of premarital agreement to the contrary, your surviving spouse, if they act in a timely fashion, can go to the probate court and say, I get a third. I get a third of the estate because I was married to that person when they died, and even though their will says I get nothing, it's called an elective share. It's called an elective share because the surviving spouse has to act in a timely fashion and elect that. Okay? There's another example. If you did your will before you got married, your spouse could get 50% of your estate if you had children, or 100% because that's what the intestate share is. So, again, that's called an omitted spouse because the thought is, well, you did the will before you got married, now that you're married, you want her to get whatever he gets whatever they're entitled to under statute. This is probably my favorite case law. The capacity to do a will is less than that needed to execute a contract. Even if an insane person may execute a will if it's done during a sane interval. This is what we call a period of lucidity is what attorneys sometimes refer to as. So if that person has a history, again, if it's a history that is chronic, maybe you can argue that they were not competent at the time they did the will. But an insane person, if they have a period of lucidity or one of those intervals of sanity, they can do a will. What that tells you, or what it should tell you, is it's really hard to contest a will in South Carolina. If it's properly executed and done the right way, really hard to contest a valid will. There are some arguments. We won't get into all that because I don't have time. But very tough, very low standard. I don't even call it a hurdle. It's a step. It's not, the capacity for South Carolina, you may not be competent enough to sign a contract or do a power of attorney, but you can do a will. All right, so this may be part of what people think about. Living trust. There's all kinds of trusts. I won't get into all of those. Sometimes there's insurance trust, there's education trust, there's revocable and irrevocable. And what I'm going to talk about, these are kind of trusts that you create separate and apart from your will. You can create a trust under your will. That's called a testamentary trust. It only goes into effect at your death. I didn't speak much on those. I have one of those in my will. At my death, if Monica's not here, I've set up a trust for my two sons, and I don't want them getting it when they're 18. I don't want them getting it when they're 21. I want them to get portions at different stages of their life. This age, or when you graduated college, when you get to a certain age, you get another percentage. You can do that in your will through a testamentary trust. This is a different device. This is a device that one of my partners refers to this as the bucket. You're basically creating a bucket while you're alive, and you're going to put stuff into the bucket, and then a trustee controls how that bucket is poured out over time. It is called inter vivos or living because it's created while you're alive. It's usually done to avoid probate costs because if it's in your trust, it doesn't pass under your will, it passes under the trust. So you don't die owning it. So it's not part of your probate estate that would pass under your will. We still do a will when we do these, but we do what's called a pour-over will. And if somebody's done a living trust and I create a will for them, their will basically says, whatever I die owning, put it into my trust. It also has some privacy because a lot of times the trust does not become a public document. A will is a public document once you pass. Because I'm going to talk about a statute here in South Carolina. Once somebody's passed, their will is supposed to be delivered to the probate court within 30 days of death. So the trust provides some avoidance of probate because you limit what's in your estate. It also has some privacy because not everybody has to see what's in your trust. It has control as far as when you distribute. It also can control how many generations you might distribute it down. One thing that I've seen it start being used for more and more is, and I'll use my family example. Let's say I do a trust and I've got 2 sons. I can say during my lifetime, everything that's in the trust, guess what? I create the trust. I'm the trustee. I'm the primary beneficiary. So it's still mine. I could still use it. I can do whatever I want to with it under the trust document. When I pass away or if I became incapacitated, a new trustee takes over for me, my wife. Guess what? She can manage it for her benefit while she's alive. At her death, it can go to my sons outright, or it can go into separate little baby trusts, one for each child, or for one for lineal descendants. So let's say I've got a son who predeceased but left 2 children. There can be a smaller bucket over there for his share or his side of it. So generally what you're looking at is person who creates the trust is called the settlor, the trustor, or the grantor. Whatever one the attorney likes to use. I use settlor more often than I do anything else. And I will get to that later. Well, revocable means I can change it, I can amend it while I'm living. Irrevocable means it can't be changed by the person who created the document unless the court says it can't be. Okay, and sometimes there's reason to do that. Irrevocable trust, you have less control once you put it into that bucket, but it also has some different tax protections, and it also has some liability protections. I think one of the misconceptions people have is I'm going to create a living trust. It's going to be a revocable trust. I'm going to put assets in there. If I got sued, it's going to protect me from liability. No, it won't. If I funded the trust with my assets, a creditor can still get to those assets. What it does protect, and this is what I want to go back to, is it protects that next generation. Let's say I've got the trust like I talked about. I'm the primary beneficiary while I'm alive. At my death, my wife's the primary beneficiary. At her death, we can hold it in trust forever for our sons. So I can separate it. But guess what? That's not my son's money. It's a trust for their benefit. So if they got sued, they're not getting to that bucket. It's not my son, so it's not an asset that a creditor can get to. So I'm starting to see revocable trust used more for liability protection for that next generation. And, today's society, I'm seeing it as kind of a informal premarital agreement. Somebody say, well, I don't know if my kids are going to have good marriages. Maybe something goes sideways. I want to protect those assets that they're getting from me, and I don't want their spouse, if there's a divorce, to get to them. So that's another thing that I'm starting to see revocable trust done for. Now, if you hold it in trust for that child, it's not their asset. They can still benefit from it because the trustee can still give them part of the bucket at different times, but what's left in the bucket is still protected from creditors and from liability. I talked about a bucket. This is more accurate as far as what the legal relationship is. It's a 3-way relationship is what a trust is. It's the grantor or the settlor or the trustor is the one who creates the document. That's the one who signs the document. The trustee is the person who is going to manage the stuff that's in the bucket and handle how it's administered. And the trust is very detailed about the power that the trustee has and what direction there is to how they use the assets. The beneficiaries are the individuals or charities or entities that receive something from the trust at different portions or different times. You can have primary beneficiaries, you can have secondary beneficiaries. The example I used, I would be the primary, my wife would be next in line, and then the kids would be the alternate or the successor beneficiaries. So that's the way to kind of look at a trust, is that the relationship of those three entities or 3 individuals. When I create most trust for living trust, that's a revocable trust, grantor, trustee, and that primary beneficiary are the same person at the beginning. It's when the settlor passes away, and now we're looking at a successor trustee, which might be an individual, it might be multiple individuals, it might be a trust company, it might be a bank trust officer. There's lots of different ways to set those up. And then the beneficiaries are the ones who are going to ultimately receive something, whether it's staggered payments, because I've seen that in trust where we'll say, I'll create a trust for my kids after my wife's passing. Son gets half of it when he turns 25, he gets the other half when he turns 30. This son, same situation. So there's ways to deal with that. There's a lot of flexibility in trust, and that's another reason why I think a lot of people use it. One, it avoids some probate costs. It also allows you to have greater control for generations down the road. Another reason why this comes into play is special needs. If I want to try to set up a situation where maybe I know I've got a family member who I would normally give something to under my will or under the trust, but they're on some type of governmental assistance, or they have some kind of special needs or some type of disability that I need to plan for. I can set up some language in the trust that creates basically a special needs trust that doesn't disqualify that first person for some kind of aid or assistance because the trust isn't their asset. It's basically there to supplement the need that they might have. So that's another reason why these come into play a lot of times. Now, you can do a special needs trust under a will, do a testamentary trust like we talked about. And in fact, if you try to set up a special needs trust for your wife, for your spouse, it has to be done in your will. It can't be done by a separate document. It's a little tricky, and it's a little sneaky trap that is out there for government purposes. Excuse me. All right. I want to hit on a few topics because I'm trying to go a little quick here. How many people have heard of the death tax? What people kind of call the estate tax. Most people don't have to worry about that. At least not most people I know don't have to worry about that. Here's why. If you died this year and have less than $12.9 million in assets, you do not have an estate tax return. You do not have enough assets that the government cares. Okay? And for a married couple, it's almost $26 million. So I don't deal with a lot of people that have to worry about this. But I want you to see this because there is a sundown provision on the law that basically says in the next few years, January 26 or 2026, if there's no change in the law, then what's going to happen is it goes back down to the estimate right now is it's going to be between 6 to 7 million per individual. And quite honestly, we do have some people where we start running into that. We're getting close against that because you may not think that, but when you look at your assets and go, well, I've got this kind of life insurance policy, I've got these retirement benefits, the surviving spouse might be getting close to that number. So that's when we start talking about more complicated estate tax planning measures, not the simpler wills or just the irrevocable trust to avoid probate. So I brought that to everybody's attention just because that number is pretty high. When I first started practicing, it was $600,000 is what the unified credit was in that one. But now we're almost $13 million. And again, even if it drops to 6 or 7, still may not be a big concern for most people. And then the annual gift you can give without having to file a gift tax return is $17,000. So that's just something to kind of keep in the back of the mind when you look at your assets and how things might pass. Probate avoidance. This is one thing that I talk to people a lot about because people come to me and say, I want to avoid probate. I want to avoid probate. I'm like, okay, well, you may not need a trust to do that. Let me look at your assets. Let's talk about what kind of assets you have. A trust is one viable way to do it. And again, usually that deals with what kind of control do you have? What is your ultimate plan as to how things want to pass? Do you want to hold it for your child's life to have some liability protection, that premarital type of agreement situation? If not, maybe we don't need a trust. Maybe what we really need to do is, do you own real estate? How do you hold the real estate? I call this, I told somebody this today, I call this the shade tree mechanic version of estate planning. If I can create a deed that helps you avoid probate for at least the first spouse, then I've done something. And one way to do that quite easily is what's called a joint tenants with right of survivorship. Quite honestly, Monica, we need to do that. I've been thinking about it for about 3 months and I haven't done it yet. And my will, one of those wills is more than 5 years old too. I didn't know that. But the idea here is you set it up in such a way that it's, right now, if you look at our deed, it says Shane and Monica. What it should say is Shane and Monica as joint tenants with the right of survivorship. Mm-hmm. The idea being when I die first, because men generally go first, Monica would own it outright. It would be hers, does not go through my estate administration, is not subject to my will, is not part of the pot that the probate court calculates to fill. It's automatically hers at that point. So that's one way to do it. What if you have a situation where my spouse is already predeceased, it's already in my name, what do I do? Well, who do you want to ultimately get it? If it's children, then we look at what's called a life estate deed with the remainder interest. I did this with my mom and my dad. The idea of this way this works is you set it up where the person who owns it, so let's say, we'll use my family as an example, I'm gone. That's usually what I do when I meet with clients. I kill off everybody in the room, and most everybody they know. So now I'm gone, Monica's living, she owns the property outright, it's in her name, we have 2 sons. She says, well, I want Ethan and Eli to ultimately get it. Then she would go to an attorney, they would draft her a deed that says, Monica's going to convey to Ethan and Eli this property while retaining a life estate interest. What that means is during her natural life, it's hers. She gets to live in it, use it. As long as she doesn't intentionally destroy it or waste the property, she has a right just like another would be. And then at her death, the kids take her death certificate, record it with the Register of Deeds, and now Ethan and Eli own that house. It didn't go through her estate either. Great device to use. Here's the caveat on that. You want to do these things at least 5 years in advance of having to apply for Medicaid. There's a 5-year look back in Medicaid, and if you gift something, they're going to go back and look at it, and it might disqualify you from being able to receive Medicaid assistance for a period of time. And when I say disqualify, which means there's a penalty, there's a formula they use to calculate that. They say, you can't receive it for another 8 months, but you can start getting it then, even though you qualify, because we're going to penalize you for gifting some property for less than fair market value. So the risk, to be fair, the risk when that life estate remainder interest, my mom's house right now, she has a life estate interest. My brother and I are the remainder. If Bill Gates rolled up and said, I want to buy that little house down there in Spartanburg, my brother and I have to agree because we are now partial owners of the property. We can't kick Mom out. We can't charge her rent. We can't tell her she can't live there. But she can't sell it without a sign off because we do have a remainder interest in the property. So that's kind of one of the risks associated with that is you are adding on multiple owners. And you have to have everybody agree to sign off to sell it. Another risk that could come into play in some family situations is if there's multiple owners and one of them has financial issues, ends up getting sued, has a judgment against them, the judgment could attach to their interest in the property. Now, I can't tell you I won't see a court force the sale of it because there's other owners, but it does attach, and if it got sold, the person who had a judgment's not getting the money, their portion of the money is going to that judgment for that. Another common way that you can avoid probate, beneficiary designations, life insurance policies, 401k, IRAs, investment accounts, anything that has a beneficiary that you can designate, have a beneficiary designation there. If you have a valid beneficiary designation, it's going to that beneficiary pursuant to that document. It's not going through your estate. Now, sometimes we'll name the trust. If we created a revocable trust, we'll have the trust as the beneficiary. Because I don't want the money going straight to the kids because they're too young. I want to go to the trust, and I want the trust to handle when the kids get it. But generally speaking, simplest situations, make sure if you got life insurance, you probably want your spouse there. If your kids are okay with receiving some proceeds from a life insurance, you think they're responsible enough for their ages or such that you think it's okay, you can name them. If you're going to name multiple children, I like to add the words persterpes after that. All that means is if a son dies before me, but he's got kids, his kids get his share. It doesn't go all to the surviving child. So those are things to kind of think about when you're looking at your beneficiary designations. If you have a life insurance policy and you have your spouse on there and your spouse predeceases you, make sure you go and name somebody as the new beneficiary if you didn't already have an alternate. Because if not, it's going into your estate. So money that you were trying to avoid the probate process will now ends up back in that pot. Transferable death, payable death accounts, or joint accounts. Generally speaking, if you have an account with your spouse, at your death, it's going to your spouse. But sometimes we run a situation where spouse is predeceased. I've got children on accounts with mom or dad. Just make sure they're set up with right of survivorship. Great case in South Carolina. I actually watched this case argue before the South Carolina Supreme Court. Grandson was on an account with his grandmother. Grandmother got sick, went to the hospital. They were joint account holders. There was an account that had grandma and grandson's name on it. Under South Carolina, you can have a joint account. Whatever money you put in that joint account is still yours while you're alive. Okay? Even though everybody can write checks on it, it's still technically that person's money. It's what you contributed to the account is still yours. Grandma had contributed everything into this joint account, just hadn't to have grandson's name on there, thinking when I go, he'll get it. Grandma went to the hospital week before she died. Grandson went to the bank, took the $32,000 out of the bank account, about 32. I'm guesstimating. I can't remember exactly. Took the $32,000 out of the account, went and opened up his own account, put it in his name. Grandma dies. Grandma's estate sues grandson to get the $32,000 back because they needed it because there was creditors' claims in the estate, and basically you have to get the money back in if it should have been grandma's, and it should have been grandma's because grandma put all the money in there while she was alive. Grandson tried to argue, well, as a joint account, I would have got it at grandma's death. Of course, says you're exactly right. But there was nothing in the account when she died, so you get zero. You owe us $32,000 because it's got to go back into grandma's money. So if he took the money out a week earlier, if he'd left it in there, he would have been hit. He would have gotten it through the bank documents because he took it out too early. He cheated himself. Great. Love that case. Here's another one on your vehicles. Look at your vehicles that you have. Look at your titles. Boats, boat motors. Either's got a title. Look at your title. Mobile homes have titles. Make sure it has or. If it's or, it's not going through the estate. It's going not through the first spouse's estate or the first owner's estate. It's going to pass, like that right of survivorship, to whoever the other name is. And again, I shouldn't admit this in public. I made that mistake when I titled one of our son's trucks. I put and Monica said, why did you... So, or is the magic word there. Again, it can help you avoid probate by having that on the vehicle cost. So if you do these things, there's going to be very small amount that's in your estate. This is one statute most people don't know about. If you have an original will, or you know where the original will is for a deceased person, you have an identity to deliver it to the court within 30 days of when you know of the person's death. South Carolina, this used to be a misdemeanor. They've amended the statute, so it isn't quite as bad. But paragraph B and C do talk about if you intentionally destroy or intentionally hide it, you could be subject to contempt, or you could have some type of judgment or order levied against you by a court. Let me talk about this for a second, because I have a lot of people say, I want to avoid probate. I want to avoid probate. With all, it's just too expensive to go through probate. Probate process does take some time, and it is tedious. But these are the probate court cost fees in South Carolina. If you have an estate where your assets are less than $600,000, it costs $95 to administer your estate. That's what the probate court charges. That's the fees the probate court charges. This is statewide. So people talk to me about, I want to avoid all fees. So I'm like, it's going to cost you more to pay me to draft a trust than ultimately what you're going to have in court fees. So let's think about that. Let's look at some of those other probate avoidance devices that we just talked about, because the trust might not be right. And I'll be perfectly honest with you. There are some attorneys who I've seen, they will prepare a trust for everybody, whether they need them or not. You get a nice binder with 60 pages of trust. And you've got some attorneys, and I used to be one of these, who never did a trust because we just didn't do enough of it that it made sense to do a lot of. And then you have some attorneys who look at the situations case by case and say, you do need one, you don't, you're close, here, let's talk about it. And I think that's the better approach. Is I have a lot of people come in, I want to do a living will. A lot of times they say living will, they mean a trust. I'm like, you mean a living trust? So we clarify that. Sometimes terms mean something. But when people come in and say, I want to avoid probate, it's just too expensive. So let's talk about it. Is it really too expensive? Not in most cases, to be perfectly frank, because there are costs associated with having a trust prepared. Now, sometimes it depends on what the real purpose is. Again, some of the liability protection for family members, right, or control, those type of things. Yes, maybe a trust makes sense. But a lot of time it is more asset specific. And here's why, if I got the right side. Yes, good. I usually draw this picture. It usually looks better when I draw it on a piece of paper in a legal pad. I draw it like a little witch's kettle or a pot instead of my little cylinder over there. But when I talk to somebody about an estate administration, I do this when I talk about estate planning, because I want everybody to realize, let's talk about what happens at the end. When you're deceased and somebody's administering your estate, what are we really dealing with? All the stuff over here in red that we talked about a little bit ago, not part of your estate. We're not worried about probate court fees because there aren't any probate court fees. What we are concerned about is what you've got owning in your name alone, and that's the probate asset. In a probate administration, that's what's subject to your will. And when I walk through this, probate administration, on average, in a simple estate, takes about 9 months to about 14 months on average. In South Carolina, here's why: creditors' claims. Creditors can file a claim against your estate. There's 2 different deadlines that I talk to people about, and this is all free because this is supposed to be estate planning. Now I'm doing estate administration. Creditors have 8 months from the first time they run an ad in the local newspaper that an estate has been opened, and creditors can file a claim. And that's usually done about a week after, at least in Spartanburg, a week after the PR is appointed. So that's why it's about 9 months to a year from date of death, whichever is the earliest. So the easiest way to think about it is a year from date of death, a creditor can file a claim against the estate up to that year from date of death in most instances. That's why the estate has to stay open, to allow creditors to file claims. Doesn't mean they get paid. They can file them. There's lots of ways to deal with them. But this is one of the things I think about is when I talk to somebody about their will, I'm like, what do you have in over you? If you've got most of your assets, and quite honestly in today's society, most of the assets are here for most people. The exception might be the real estate, but we can do a joint tenants right of survivorship and not have to maybe have to worry about that being at least one of these sets. So these are the kind of things I think I've talked through with people with is when you sit down, you want to make sure, when I meet with people, I want to make sure I know what their assets are to see what falls into which categories, because then I really know what a will is governing. And if I can help people get things out of the will context, that's what I want to try. So I went a little longer than I wanted, and I moved quick, so I apologize for that. But big picture, the 4 main documents, 2 of them while you're living, the healthcare power of attorney and the durable power of attorney, are critical to have people who are in place ready to make decisions and help manage your affairs. The trust is a document, gives you some flexibility, gives you some more control from the grave, to be perfectly frank, because you may control when things get poured out to family members down the road. And then the idea of the will, if it's just a document that speaks to death, whatever you might die on. One thing that I hate that we don't do, and y'all bear with me, I'm a history nerd, and I have a book somewhere. Oh, that's over here. Sorry, camera. We call it last will and testament, and I'm really bad about this. I never discuss it with clients. Do you ever give a testimony in the document? We don't nowadays. But our founding fathers did. And I want to read part of John Jay, and I like John Jay, and some of you may know why. John Jay was the first Chief Justice of the United States Supreme Court, one of our founding fathers. And this is an excerpt from the opening section of his will. Unto him who is the author and giver of all good, I render sincere and humble thanks for his manifold and unmerited blessings, and especially for our redemption and salvation by his beloved Son. Blessed be his holy name. We don't use the testament part of our wills as much as we should. And how can you do that? Well, you can be good stewards, and you don't have to give all your assets to family members. You can have churches, you can have charities, you can have other organizations you want to support. You can address those in your will. It's called specific bequests, specific devises. It's a good way to do that. But I wish more of us would take time to say, what is the message I want to send? This is from David Martin, The Original Intent. I've had this book since before I went to law school, actually. I did a paper in law school about the original intent of the Establishment Clause, and I got a lot of the information. I started kind of pushing me that way out of this book. But there's different excerpts from some of our founding fathers' wills, and it's amazing to hear their testimonies about how dependent they were on God, or how grateful they were for salvation, specifically from some of our founding fathers. And that, if you ever can't sleep at night or get bored, maybe go a Google search on some of those things and what you want to do, because a lot of times it's messages to their children. And as a father, that's another thing where they're sending messages to their children saying, I know you might have a chance to look at my will after I'm gone, so I want to make sure I tell you some important things. I wish we did that more, and I really do want to kind of challenge myself and some of the other attorneys in the office to start telling people, look, why don't we can put something with the will that has something that is meaningful that you want to pass along. So, all right, well, that's all I have as far as my PowerPoint on my topics I want to cover. We're a little late, it's 10 after. I got people staring at me through the windows, but if there's some quick questions, I'll try to address some stuff. Yes?
I have a question. If you have your driver's license and it says you're a living donor, is that a legal document that says yes, regardless of what the agent said?
It's a good question, and I don't know. I would tell you, if you want to do that, do the healthcare power of attorney and initial the box the same way. I have a lot of people who look at it and go say, I got on my license instead of initial the door. But again, I'm not sure how the medical providers would look at that and treat that. It's not an issue I've ever had go up. Yes?
You need to have both the durable power and the healthcare power of attorney. It is durable covered.
Durable, some attorneys do it as a combined document. This is a good question. One of the attorneys I work with, he does one power of attorney that has what he calls the financial powers, and he has one that has healthcare. I do them separate, but I would encourage to have both if you have somebody you trust to do it. Anything? Yes.
When you're talking about valid beneficiaries on all those other documents, is that just whoever you sign up with?
Well, and the reason I say it that way is, let's say my mom, for example. My mom and my dad is her beneficiary on all of her life insurance policies, and no alternate. And my dad predeceased her. He was valid at the time, but at her death, he would not be a valid beneficiary because he's not there to take. So that's what I meant. It's that the beneficiary is no longer there to take or to be able to receive the funds.
So you don't need any extra notary or anything?
No.
All right.
Yes.
Shane, I encourage people, this is not going to benefit me at Morningside, but to tithe to their church or missionaries, they're in them red.
I think that's good for you. And I do have, it doesn't come up as much as I would like it to be perfectly frank. But, and to be honest, where most people think about it is what I call the last taker provision, which is where after all my family are gone, here's where I want to go. And, I can't really direct people, but I'm glad you can encourage them because I can't tell clients what they need to do. But I do think that's something that people don't think advantage of and don't think about it when they probably should.
Is that generally a net worth number that you leave before a living trust is even?
It's not so much the number as it's the nature of the assets. If you're doing it for estate planning purposes, we've saw those numbers, but most people are doing it usually for more control, more so than even the dollar amount. Do I need to use a document while I'm alive and go ahead and set it up and have control? If it's just for children, you could do it under the will, but then very similar provisions, whether it's a testamentary trust versus a living trust. The question is now, do you want to avoid probate? So there's not really a magic number. It's more of what are the nature of the assets. At least that's how I look at it. Yes.
If we hear of the witnesses on the will predeceased you, does that invalidate the will?
It does, and that's a good point. I didn't get into all that. There's another provision at the bottom of the will. When somebody signs it, you sign the will twice, the way most attorneys draft it. There's a signature of the will, and then there's what's called a self-attestation clause. And as long as you have a self-attestation clause, which basically says the testator signs it again saying, I'm doing this freely and voluntarily, I'm over the age of 18, or I'm aided by family court order, I'm doing it of my own free will, nobody's forcing me to do it. They sign that. Then the two witnesses say, to the best of our knowledge, the testator signed this document. They're under no undue influence. They're over the age of 18, sound mind, no undue influence. They both sign there, and then it's notarized. So it's basically a self-attestation clause is basically like an affidavit where the testator and the witnesses are saying, testator's doing this freely and voluntarily, they're sound mind. The court will admit a document to probate if they have that original will without making the witnesses show up to testify. So that's what the self-attestation clause is, what is the way to get the document admitted to probate. Doesn't require a self-attestation clause, but it's the better approach because it allows to be admitted to probate. If you don't have a self-attestation clause, the witnesses can be and usually have to go to court and testify under oath that they actually saw the person sign it. They believe they were over the age of 18 of sound mind. The same kind of stuff we put in that provision is signed under oath. They would have to testify under oath to that effect. So most attorneys are going to have a self-attestation clause in any South Carolina.
Shane, I've heard that if you're going to inherit property or business out of state, that it's helpful to have a trust to protect that transition. Is there anything about that?
It can be depending, especially if it's coming, but again, in my mind, I don't want the person who's going to give it to you to create the trust. Because if it comes into your name and then you put it in the trust, it's not a liability protection. You may want to look at a limited liability company or put it into an entity to have some protection there for liability. But if you inherit it and then you put it into the trust, you don't have that liability protection. Yes, ma'am.
Just a suggestion, if you are dealing with a second marriage and you want to leave everything to the children, make sure you get it done legally and properly in writing before you get married. Don't go on the pastor and I in our marriage counseling agrees.
Yeah, and I had never done premarital agreements until the last year and a half. It's the first time I started doing those. And doing them before marriage is the way to go because it helps get everything clarified. And also, a lot of times what we'll do is in a premarital agreement, we'll also waive that elective share that we talked about. But there are some specific ways that those have to be done. I didn't cover those tonight, but have to be two attorneys involved. The soon-to-be spouses each have to be represented by a separate counsel, have to get a full disclosure of the nature of the assets so they know what they're giving up.